All right, welcome to this explainer. I am absolutely thrilled to have you here today. We are going to unpack a truly fascinating clash between a classic American ideal, that lush, perfectly green neighborhood lawn, and the very harsh, very dry realities of the modern desert. We've got high stakes, we've got passionate neighbors, and we are taking a deep dive into the everyday rules that literally govern the places we call home.
Okay, let's dive right into this. On the surface, pulling some weeds and planting a few cacti sounds like a simple landscaping chore, right? But what happens when replacing grass with a desert landscape suddenly sparks this massive, neighborhood-wide tension? At what point does a landscaping choice stop being basic maintenance and cross a line into a fundamental, legal change of use that actually demands a democratic vote?
Well, to really get to the bottom of that, this explainer takes us straight into a formal legal proceeding at the Office of Administrative Hearings in Phoenix, Arizona. And make no mistake, this isn't just some petty squabble over a fence between two neighbors. We are talking about a formal, high-stakes matter of real estate law, complete with sworn testimony, cross-examinations, and a really rigorous analysis of community governing documents.
Section 1. The Battle for the Lawn, the Spark. So our story kicks off in a beautiful, master-planned community called the Villas at Desert Camp. The spark that ignited this entire legal showdown was the Homeowners Association's decision to rip out existing grass in the neighborhood and install desert landscaping, something commonly known as xeriscaping. And the core of the issue? The HOA went ahead and did this without putting it to a community-wide vote.
Now, to really understand why the homeowners reacted the way they did, we have to look at the sheer scale of the project. We are talking about the removal of roughly 1,300 to 2,300 square feet of turf in a single go. For the homeowners, this wasn't just, pulling a few weeds or swapping out a dying shrub. This was a massive undertaking. It physically transformed the visual and functional landscape of their daily environment overnight.
The absolute flashpoint for this dispute was a specific parcel located around 9191 Eastland Road. While this particular address does include a private lot, the dispute very quickly bled into the adjacent community common areas. What used to be this contiguous stretch of green grass was carved up, and significant portions were replaced by dirt, rocks, and desert plants. Naturally, this sudden visual and physical shift sparked a serious legal dispute between the residents and the HOA board.
Moving on to Section 2, the homeowner's argument, protecting the community's voice. Let's look at this dispute impartially from the perspective of the petitioner, homeowner Kay Long. Her case isn't just about preferring grass over rocks, not at all. She framed her entire argument as a defense of democratic voting rights and the protection of the community's voice within the neighborhood. Now, what's really interesting here is how her own words cut right to the emotional and practical core of the grievance. Kay Long testified, "This turf area served as an open space, a shared community amenity, converted to desert landscaping without a membership vote. To her, this wasn't just decorative grass. It was a functional space. It was where neighbors gathered, where people walked their dogs, where grandkids played. By removing it without asking, she felt the HOA had fundamentally stripped the community of a valuable asset." So if we break down the homeowner's logical argument, it really rests on a few solid pillars. First, the permanent loss of functional recreation space. Second, the permanent removal of the irrigated turf system itself. But the real smoking gun for her case was the accounting. The HOA's own financial records actually categorized this landscaping project as a capital improvement. She logically argued, hey, if the expense is big enough to be a capital improvement on the balance sheet, it clearly goes way beyond standard routine maintenance, and therefore it legally requires a formal membership vote.
All right, Section 3, the HOA's defense, practicality and preservation. Let's impartially flip the coin and look at the other side of the aisle. The respondent in this case, represented by HOA President Ron Stacy, offered a staunchly pragmatic defense. The board argued they weren't acting out of malice at all. They maintained their actions were driven entirely by practicality, financial responsibility, and environmental preservation.
And this brilliantly illustrates the massive disconnect between the two parties. Stacy testified, "This is an area of dead grass. Dead because of the shaded areas. A real eyesore. Literally looking at the exact same spot, the homeowner saw a usable park, but the HOA president saw a failing, muddy patch of 15-year-old dead Bermuda grass. Because of the dense tree canopies blocking the sun, the grass just wouldn't grow, turning the whole area into a perpetual eyesore that brought down the community's aesthetic."
The HOA actually backed up their defense with some incredibly compelling evidence.
They pointed to the dense shade and severe water runoff issues making the grass impossible to maintain. Plus, they were facing looming water conservation mandates from the City of Scottsdale and the Arizona Department of Water Resources. Oh, and here is the absolute kicker. The HOA actually secured an $8,000 rebate check from the city for doing this. You have to admit, getting paid $8,000 by the government simply to stop watering a patch of dead mud is a pretty strong financial argument for the board.
Then we have Aaron Margot, the community manager, who provided some really powerful testimony about how HOAs actually function day to day. He argued that the board is elected specifically to make maintenance decisions. If the HOA had to organize a formal community-wide vote every single time they needed to replace a patch of failing landscaping or fix soil erosion, it would result in total community paralysis. The business of running the neighborhood would completely grind to a halt.
Which brings us to Section 4, the CC&R Showdown. Legal definitions face off. Let's move to and see how this builds into the final, crucial legal showdown. Everything we've discussed so far, the dead grass, the grandkids playing, that $8,000 rebate, all of it ultimately funnels down into a strict interpretation of the neighborhood's rulebook, the Covenants, Conditions, and Restrictions, or CC&Rs.
These two conflicting legal arguments capture the entire battle in a nutshell. We essentially have two very different rules pitted against each other. The homeowner relies on Section 4.6, which mandates a membership vote if there is a change of use in a common area. But the HOA relies on Section 8.2, which explicitly states the elected board is the sole judge of appropriate landscape maintenance. The judge's entire ruling hinges entirely on which of these rules actually applies to ripping out a lawn.
It all comes down to defining three little words: change of use. Did the property actually change from open space to something else? The homeowner argued that, yes, the character and function of the space fundamentally changed from a recreational park to a purely decorative, unwalkable space. The HOA countered by arguing that the official legal plat designation of the land never changed at all. It was zoned open space when it had grass, and legally it is still zoned open space with desert rocks. You can still technically walk on it, even if it's not as soft.
So the crucial point is how the HOA interprets the threshold for a change of use. According to the HOA president, if we put a building on it, we made it a recreational facility. Absolutely, the membership would have a vote, but there was no change of use. For Section 4.6 to trigger a community vote, they believe the board would have to install a physical barrier, like building a clubhouse, putting up a fence, or pouring concrete for a pickleball court. Because they simply swapped one type of ground cover for another, they maintain that no legal change of use occurred.
And that leaves us with a massive macro-level question to ponder today. As environmental mandates push for sustainability and water becomes increasingly scarce, who actually holds the power in your neighborhood? Is it the democratic voice of the residents who just want a green place to play? Or is it the elected board tasked with financial and environmental compliance? It's a fascinating look at how global climate realities are literally changing the legal landscape of our own front yards. Thank you so much for joining me for this explainer. I really hope this helps structure and clarify a truly compelling legal dispute.